Just a few moments ago, before the State Capture Commission of Inquiry took their lunch break, the former chair of SAA, Dudu Myeni, ousted an anonymous witness who previously testified about her son, Thelente, allegedly receiving state contracts. Now, the man previously known as Mr. X said that he feared for his life and needed to remain anonymous. The Zondo inquiry adjourned very abruptly as the deputy chief said that he will make a ruling about Myeni's conduct after the break. Now, for more on this, we're joined by Llewlyn Curlewis, who is an attorney. Thank you for your time, Mr. Curlewis, this afternoon. What exactly are the implications of what Dudu Myeni has done? A witness wanting to remain anonymous because he fears for his life, now being mentioned.
To everybody. Well, let's start at the beginning. First of all, there's a principle in the South African legal system that suggests that all witnesses, as a rule, and there are a couple of exceptions obviously, are generally speaking both competent and compellable to testify. That's a tried rule in the South African system. So, in essence, from the perspective of, let's start with Dudu Myeni. Obviously, she's entitled to she's obliged to testify, but she's not necessarily obliged to answer questions that might incriminate her. And that is one of the reasons why, from her perspective, on numerous occasions, she indicated to the Zondo Commission that she's not prepared to answer questions that might implicate her later at a criminal trial that is in the foreseeable future coming her way. And the reason why I say that is that there's already an indication from a High Court in the ruling of Judge Van Nieuwenhuizen previously that declared her a delinquent director. So on the table is possible criminal charges being lodged against her in the future, and therefore any questions from the Zondo Commission that might incriminate her later at that trial, criminal trial in the future, she's not obliged to answer. And that is also a principle of our law, because from a constitutional point of view, every accused person has the right to remain silent and not incriminate himself against possible criminal charges. From the perspective of this witness that wants to remain anonymous, they obviously the prerogative of the presiding officer, in this instance Judge Zondo, to decide whether it's in the interest of justice that the identity of this witness is protected for purposes of the bigger picture. Now, if there is real reasons to believe that this person's identity, if known, might be jeopardizing the safety of the individual, or is not in the interest of justice, or might implicate state security, then obviously there are ways and means to accommodate that witness and to see to it that that evidence is then held in camera. So there are a couple of options here available.
So what Mr. Myeni has done now is ousted the individual who wanted to remain anonymous. What are the implications of this on the Commission, and what are the implications on Mr. Myeni?
Look, the Commission is not a court of law. So although there are in many instances a duplication of principles that we typically see in our courts of law that is applied in commissions of inquiry, they do not have all the sanctions available that you will typically find in a criminal trial. Although, when it gets to contempt of court, and that is for Zondo to decide after listening to evidence and arguments on both sides, to decide whether this was a contempt of the inquiry, in other words, the principles and the legislation that brought the inquiry into legislation. And if convicted on that basis, and if the court is then of the opinion, or in this instance the commission is of the opinion that she actually contravened some of those principles, then obviously it must be held that she did it intentionally, and if so, then she could be in contempt of the inquiry, in which event the same sanctions that could be handed down in a criminal trial for contempt of court, in fact, curia, we refer to it as a general rule, can apply here in this instance.
And so if one is held to be in contempt of the Commission, what would be the retributive action that would pursue?
Well, the court can obviously there and then, in a summary fashion, convict you of such a transgression, and you can be looking at the penalty, fine, and even a jail time in certain instances. But usually what happens is that the inquiry will make a recommendation to the Director of Public Prosecutions to consider whether formal criminal charges should be laid against this individual to be determined at the later stage in an independent criminal court where evidence can be laid against and in favor of that witness or a person to decide ultimately whether he or she is guilty of the transgression.
Now, the individual whose anonymity has been transgressed, do they have a role to play in this? Could they then turn around and say Ms. Myeni, interfered with their rights of anonymity?
Yes, of course. I mean, it's quite clear that this person may argue that as a result, his or her life is now in danger, or certain issues and personal privacy issues was jeopardized, and as a result, they might even follow a civil claim for damages against the Dudu Myeni or any of the other individuals involved. So I foresee that the individual will definitely seek legal advice to determine what other remedies in law is available for that person. Correct.
So now, it is the lunch break, and what the Deputy Chief Justice said is that he will deliberate during this lunch break and decide what it is that he will do. What would you, as an attorney, say would be the key considerations in how he chooses to move forward?
Well, first of all, from the perspective of Dudu Myeni, I do not think that anybody can argue that she's not entitled to make use of her right to remain silent every now and then when she might possibly incriminate herself for future purposes. So on that level, there's nothing wrong with her decision and her legal advice. From the perspective of obviously mentioning the name of this individual that she was not supposed to mention, for example, on that basis alone, the judge should consider whether he is going to tolerate that stance, and now that it's public knowledge, whether he's going to entertain it or make other arrangements to secure the individual's privacy and maybe even identity for further purposes. But it's a difficult issue because obviously it's now in the public domain, and once in the public domain, there's not much you can do about it. But making counter arrangements and maybe asking the assistance of the SAPS to ensure the safety of this individual for further purposes.
Mr. Curlewis, your insight much appreciated this afternoon. Thank you for your time.